is Boadu TV. Truth and integrity.
Yamamu nyina okabai Boadu TV sunye na Adom Otchere afaya dia fa demonstration a minority for ayeye ana nyina ne se Chief Justice Madam Tokonu NDC ene Mahama yine sinchen ama montiase save the judiciary nya sanketwa enkramonten so demonstration na chese anu odempa na enu na Adom Otchere so abuewurem so mso so lawyer oh yes Paul so abuewurem adudu ma baba mu na court ko asetena ruling ne baye enesen Madam Tokonu yese kwampaso ene yi na nasenya kwampaso Adom Otchere bichim we anu sinchenya the republic against anase versus abrantia ono yese wedi omane wu papa edubu ahen one ne yere eno so case na ko sisen attorney general edi bia san be boom Paul Achrem.
People don't understand, they can't comprehend what you are doing. They can give it any name. So you may be filming and doing a production, and somebody who doesn't understand will say that Uchasini and stuff like that. When you are doing certain things and people can't follow, they can't sit through the program and follow 15 minutes, they can't follow. They just don't understand what you are saying. But they know that you are doing something, but they don't get the themes of what you are discussing. They can call you any names. But fellow bloggers, good evening. Welcome to our blogging night. Tonight we have a lot to talk about. Let's begin with the I was quite impressed with the crowd of the Chief Justice demonstration. Alexander Afenyo-Markin, where are you? I think you did a good job of mobilization. They have been accusing you of slapping a policeman or hitting a policeman. I've seen Alexander Markin's statements. I think that sober heads should prevail, and let's deal with that. I sympathize with the policeman, but I also see Alexander Markin. Let us work on it and be fine. We should be fine after that. Offense sometimes happens, so let's calm down and deal with it, okay? But I was really impressed with the numbers of people who turned out. Should that be an indication, any kind of indication to those who are on the side of the argument that the CJ must go and must go this way? Should that be? I like this one. These people presented themselves like judges, didn't they? And they walked as part of the demonstration. I think this was very impressive. And it means that a bit of time had gone in, a bit of thinking had gone in, and they create a bit of sense of humor. But they make their point very forcefully, and they say that they are about attack on the judiciary. They are suspecting that if Justice Tokonu is truly removed, after that, at any time, people can write a petition to remove a Supreme Court judge or a justice of the Court of Appeal, and it might work. So they are quite worried about the process in this regard. But let's see a few more photographs. This is Nana Boache, who was also one of the conveners of this massive demonstration. I mean, they must be very proud of themselves that within 4 months of a new government and within 4 months of such a massive victory by the ruling party, that they could raise this significant amount of people in the audience. I thought that was really impressive, significantly true, that it was very, 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 very impressive. What does that portend? And tonight, oh, my producer, he needs to do some work. Tonight, we're going to show you something about President Mahama's 120 days is coming up on Wednesday. I told you we are doing a documentary for it. But President Mahama will not have another opportunity to talk about 120 days. So this is the first epochal occurrence in his government that he doesn't have the opportunity to repeat it. The point I'm making is that President Mahama read a sessional address in 2025. He's going to have the opportunity to read another sessional address in 2026, in 2027, in 2028, and even in January 2029. But with this 120 days in office, he's not going to have an opportunity to do it again. This is the first time he's gone and done. This is the second and final term. So what are we saying? Since he's doing it tomorrow, after tomorrow, the race for who becomes the next NDC leader has certainly begun. We'll be showing you photographs of all the people who are going to give Johnson Asiedu Nketia a chase for what Asiedu Nketia believes is his birthright, the inheritance of the leadership of his party, the National Democratic Congress. That's coming up tonight. A good story that you should wait for. Fellow bloggers, are you there? We are blogging out tonight, isn't it? All right. So this is so these are the photographs from the demonstration. I'm saying that it was massive. The placards read, suspending the Chief Justice is red line. Some says Mahama is a dictator. Some say Mahama is a democratic dictator. Mahama this, Mahama that. Was all over on all of the platforms on the placards. But they must be commended. This was very, very massive. I think this is bigger than any of the demonstrations we saw in 2019, 21, all the ones that Oliver did. It doesn't mean that a demonstration is not big. Doesn't mean it hasn't been impactful. If you learn and study about pressure groups, it's not the size of the demonstration, but the size of the demonstration is also important in terms of gleaning how many people will physically present themselves for something like this. Sometimes people agree with the concept of what you are demonstrating about, but they don't physically present themselves. But here you are. There may be a lot more who agreed with the concept of what the demonstrators were about, but they did not physically present themselves. So this is really good. This is massive. Nana Boache, congratulations. You guys did a wonderful job. And this is the king of the whole action, Alexander Afenyo-Markin, the indefatigable minority leader of the mighty minority. I can see Patricia PJ in the background. These guys are doing an excellent work. We didn't know that Alexander Markin has that much fire in his belly. Sometimes being in opposition is good. And it's all part of the way that democracy works to shape up things in the country. We have now seen the multi-talented person that Alexander Markin is. We didn't know that. When he was majority leader, when he talks, they are laughing at him, they are shouting at him, the petrol price is up, this is up, this is up, we should get out, da, da, da. Now he has no responsibility for petrol price. Now he has no responsibility for ECG. Now he has no responsibility for anything governance. His responsibility is the democracy. And we are seeing that the NPP and Alexander Afenyo-Markin seem to have a lot of the right stuff in them to be able to help this democracy to be sustained. Afenyo, I salute you. I salute you. Recently, he's been made a chief, so they call him Osahene as well. Osahene means the king of war. You know that. Those of you who go to church in Pentecost and Assemblies of God, they sing a song, Osahene Christo Mumani Dinso. Oyohene, Nahine Dana Betty so. Obefred no say. We know that song, yes. So Osahene, king of war. Forgive my voice. Bloggers, are you with me? We are blogging out tonight. So that's our first story gone on this one. Should I get text messages? Okay, no, let's move on. Tonight we have a lot to talk about. Okay, we are going to get into the details of what happened at the Supreme Court. From the interesting changes that occurred in the bench that heard the matter. The bench just means the group of judges. The lawyers call them the quorum if they are reporting in the case. But the group of judges who heard the matter. They are the bench, or if you like, the panel, just to make it more simple, the panel. Interesting changes in how the panel changed from the first panel Justice Tokonu set up to the second panel that Justice Bafuboni set up. All of those things will be coming in. Okay, end of this story. My lady, this is the end of this story. Let's get on. Oh, you wanted me to show one more photograph? Okay, I like it. They gave me one more photograph. They thought I should look at this. Okay, I like it. So this photograph is Patricia PJ, Alexander Afenyo-Markin, Nana Boache, and Richard Ahiagba, who is the Director of Communications of the New Patriotic Party. Very, very, very good work by these guys. They went out, they made their case heard, they made their voices heard. And, this is Mampong MP. And this is Oseya Oduchum. I can see that this is Shaibu. Oh, beautiful. And this is Akwesi Akwa. Oh, Akwesi, how are you? Hey, Acho. Oh, my fupa. Akwesi Akwa. Akwesi Akwa for many years was the producer of Kwame Sefakai's show. The beautiful Peace FM morning show that we don't hear anymore now. One of these days we'll come to that story. Akwesi Akwa used to be the producer. It's very, 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 very hard-working man. And Patricia is here. Alexander is here. Mampong MP is here. Mampong MP Yako. Mampong Hine has died. Viewers, you know that. Unfortunately, Mampong Hine has passed. I'm sure there will be enough occasion to mourn Mampong Hine on this program. Shaibu and Oseya Oduchum, we're all in action to support the demonstrators. Alexander Markin again with Patricia PJ, the deputy leader. Alexander Markin by himself. And this is the leadership, I guess, at the beginning of the event. They were able to throw enough people on the street to make the case. And I think that is a very, 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 very successful event. This was very good. I saw some people writing and saying that if Akufo-Addo doesn't go on the march, then he doesn't believe in the process. You want an 82-year-old man to go on a march to be marching because he believes in a process. Oh, Ghanaians, leave Akufo-Addo alone. Why? Leave Akufo-Addo alone. You know, he's a master craftsman. Okay, end of story. Last Tuesday, or was it Wednesday? Last Friday. Kwabena Aduboahin was returned to courts. And what happened on Wednesday is that after he had been invited to Iyoko or so, he was told in the afternoon that the court process is waiting and that he has been charged. So together with his lawyers, they went to court. When they went to court, it was about 4 p.m. in the evening, as I'm told by the lawyers. The court was sitting. The judge was already there. That surprised Otchere a bit. Because it was 4 p.m. and typically judges would have closed by 4 p.m. But on this occasion, the judge was there. And then the Learned Attorney General, Leonard Dominic Ayeni, made the case that he was interested in keeping Kwabena Aduboahin in for a while, pending his investigations. And the judge said he should come and argue that on Friday. Otchere said that on Friday when he was going to court, he was aware that no judge was going to grant something like this because, as Atta said, and I don't know whether you still have the words that Atta used that I sent to you. If you have it, make it ready and I'll show it at the end of this. As Atta said, it is incongruous to understand how the Learned Attorney General has kept Kwabena Aduboahin in for 2 or 3 weeks, held a press conference and indicated all the offenses of Kwabena Aduboahin in a press conference. After the press conference, the court grants Kwabena Aduboahin bail together with his wife, which takes him a long time to fulfill the high bail conditions. Otchere actually goes to court to amend the bail conditions. The court agrees with him and reduces the bail conditions to a certain 80 million Ghana cedis for him to find some evidence of 80 million Ghana cedis before he is let out to go. That happened and they let him go. And then after that, it took another 3-4 weeks before the Kwabena Aduboahin was formally charged. Otchere doesn't understand what more time the Attorney General needs. And indeed, on that Wednesday, the Attorney General returned to hold a press conference. He did. And said again things that Aduboahin had done and introduced new things. And while Otchere says all the allegations against Aduboahin will fall flat in the court, and Otchere strongly believes in that nothing is going to work, everything will fall flat, he does not understand why the Learned Attorney General is looking for more time. In fact, Otchere said that in his press conference, the Attorney General was talking about plea bargaining, that Aduboahin can come for plea bargaining. And Atta was confused that you have not presented any real evidence in the court against the accused person. And you're already asking him to come for plea bargaining on the whims and caprices of your decision that he is guilty when you are not the court, you are not the judge. What kind of law is this? Atta fumed. What kind of law is this? He told the media. You are the Attorney General. You are prosecuting the man. You have found charges against him that must come to court and stand the test of time. It is in the process of you presenting this evidence before the court that the person will decide that based on this evidence, I will do plea bargaining. But then you are inviting him to do plea bargaining because you have filed charges. And Atta says that he smells a rat in all of these things. He also told the media that he doesn't want to pick phone calls from the Learned Attorney General, that he's his good friend. The Attorney General has been calling him, that he has seen the phone calls, but he will not answer them. You know why? Atta is being very smart. He says he will not answer them because we have history where these people can record your phone call and come and say that you said this or that. And so in good faith, he doesn't want to talk to the Attorney General whilst the prosecution is during the subsistence of the prosecution. He doesn't want to speak to the Learned Attorney General. And many lawyers have been having this conversation for the last few days in their chambers, and they are thinking that this is very sad, that lawyers cannot talk to each other even when they are doing a case, which was one of the basis of legal practice, that they always talk to each other as learned friends, that now you can't anymore because these people are going to be recording. This is who they are. They'll record. They'll record and say, hey, you said this, and you said that, and you said that. And it's completely unethical. So people are sad that we have come to the point where a lawyer says, I will not pick the Attorney General's call, because if I pick his call, he's going to record it. I don't believe that Dominic Ayeni will record any call from Atta. I don't believe it. But we must all understand that we have come to this place because of yesterday. Because yesterday, we heard that an Attorney General's phone call discussing about a matter that he was prosecuting was recorded. And political parties held press conference and played the recording. And the lawyers in those political parties were not able to tell their political party colleagues that this is an anathema to the bar and the legal profession. Please don't do it. They didn't tell them. They didn't tell them. So we are in a situation where the cooperation between the defense lawyer and the prosecution has completely broken down, because the defense lawyers are worried that if I engage with the prosecution, somebody will be recording, and tomorrow at a press conference, they will play it. Sad, isn't it? Sad. But we can recover. We can recover. We'll recover beautifully. As a country, as a democracy, as a people, we will always recover. Haven't we come from 1962? We have come from 1969. We have seen the revolution of 79. We have seen the hunger of 1983. We have seen the deadly murder of 3 high court judges and a retired army officer. We have seen 1992. People were burnt to death after the 1992 constitution came into being, the 1992 elections. We have seen 2008, where we went almost into the brink with a 25,000 difference of votes. Nana Akufo-Addo saved this country by conceding defeat. We have seen it happen all the time. We have seen it in 2016 when there was a bit of confusion. John Dramani Mahama conceded defeat. We saw it in 2024 when everybody was burning everywhere early in the morning. Alhaji Mahamadou Bawumia conceded defeat. So we will always go through these challenges and we'll rise up again. But for now, we are sad that defense lawyers cannot speak to the prosecution. They will not speak to the prosecution because they don't want to be recorded, and then it comes to a press conference. Why are we doing this to ourselves? Because of politics? No, we shouldn't. We shouldn't do that to ourselves. We shouldn't. So the Kwabena Adom has now been asked to stay in cells for 7 days because the Attorney General says that if Kwabena Adom goes home, he may interfere with the witnesses. The big question is, who are the witnesses? There are no witnesses as far as Kwabena Adom and Otchere are concerned. They have not been told of any witnesses. When the case starts, the prosecution will indicate to the court that we will be calling 11 witnesses in the person of Paul Adom Otchere, Kwame Sefakai, Kweku Baako Jr., Kwesi Pratt Jr., Dr. Nyaho Tamaklo, Alan Martin, Boachi Ejaakon, Asiedun Ketia, Fifi Kwete, Sami Jemfi, and Omane Boama. 11 witnesses will be called by the Attorney General. That's how it always is. So the Attorney General will list them out. If at that time, the Attorney General says that we don't want Kwabena Adom to be talking to Paul Adom Otchere because they sat on the NCA board together, many people will understand. But Otchere is confused tonight because he says, you have not even told us who the witnesses are. And then you say that he's interfering with the witnesses. Okay, so why don't you cocoon the witnesses and take them to Kempinski and put them there at the state's cost, so that every morning you give them bacon and fried eggs and awuza cocoa and keep them there so that you are sure that neither Kwabena Adom nor Otchere nor Paul Adom Otchere or Omane Boama can see those people. That's a better way of doing it. Because if you take Kwabena Adom alone out, and I know the witnesses too, I may be part of a syndicate that Kwabena Adom was running. I can go and talk to the witnesses that, hey, this, that. But nobody understands it. What is Otchere saying? Otchere is saying that he's alleging that there is no honesty in the reasons that the Attorney General gave to the court to keep Kwabena Adom in, except one personal matter. He's alleging that Otchere says that the Adom brevity in taking out a writ of defamation against the learned Attorney General is what has annoyed the Attorney General, so he wants to teach Kwabena Adom a lesson. We do not know whether the things Otchere is saying is correct. But these are the matters that Otchere is strongly alleging before the court. Is it true that Kwabena Adom has taken out a writ of defamation against the Attorney General? The answer is yes, he has. Has that happened before? The answer is no, it hasn't. Could that offend the Attorney General? We don't know. But the defense lawyer is saying tonight that the reason why, if you can't find any reason for Adom incarceration for another 1 week, but the only reason could be that the Attorney General is trying to teach him a lesson using the power that has been given to him by the state through the process of democracy and an election, to teach him a lesson that you are not the same with me. You cannot be equal with me before the law. You cannot sue me in defamation. Are you sick? Are you mad? You sue me in defamation, you will stay inside. These are the allegations of Leonard Otchere. These are Otchere's words and his allegations. That this is what counsel on the other side is doing. So on Friday, today is Tuesday, on Friday we are all going to be in the court to listen to the arguments. When Adom comes out, or when he comes back into court, we're going to be listening to the arguments to understand what's really happened and what has happened and what the Attorney General would like to say. But we are very, very sad about this development. We believe that Adom will get a fair trial. We believe that democracy will always succeed. He and his lawyers believe that he's completely innocent. and that will come out, and then we'll see it. But this issue of going to prison, going to jail, I'll teach you a lesson, those things we shouldn't be doing. Hopefully, Dominic Ayeni, the Attorney General, is not doing that. The panel for the initial action, and here there are 5 of them. We'll then show you how the panel then changed after Justice Bafoboni became the acting Chief Justice. He re-empaneled. We'll tell you who he empaneled. He has a right to do that. That's a right to do. He re-empaneled himself and other people. We'll tell you about that. We'll tell you about the argument that was made in court that was initially overruled. Godfrey Dame was surprised to see Justice Bafoboni on the panel, and he raised an objection about it. Tonight, I've spoken to one important Supreme Court judge who's telling me that there's another reason why Justice Bafoboni sat on the panel, that there could be another reason. The Supreme Court judge told me that tonight. I'll be sharing with you, of course. I told him that I'll be sharing with my audience tonight. He said it's fine. It's part of legal education, so I should share with my audience. The other reason why Justice Bafoboni was there. And then we will also talk about how the 2 applications for live coverage were both denied by Justice Bafoboni. Incidentally, one of the applications was from here. Good evening, Ghana. We wrote a letter to him wanting to continue with the live coverage that Justice Tokonu had started. You remember that all the cases of December 2024 came on live on television. So we are very used to that. When election petition 2013 was shown on television, we were all very excited, and it ended until election 2020 was also shown on television. But since the last 1 year and a half, Justice Tokonu has allowed the case of the 3 vacant seats in Parliament was on television. The case of the LGBT was on television. And there was a third one, I can't remember. I think that was also the vacant case or e-levy, something like that, was on television, where we saw, of course, Justice Tokonu arguing Tadeo. Sorry, all the videos that you see these days, it was from her administrative pen, permitting live coverage, because in her own words, Justice Tokonu said she wanted Ghanaians to see that how the judiciary and the Supreme Court works, so that it's all demystified. It also helps us reporters so that we're able to report better, and it also puts some pressure on the lawyers. So when they come out of the room and they are having their arguments, they know that we all saw it. So they are very careful on what to say and what not to say. By a 3-2 majority, decided that the suspension of the learned Chief Justice, Justice Gertrude Tokonu, was not unconstitutional, that it was lawful. Before the event today, when the news came out that President Mahama has sent, it was a news item released by Felix Kwachiofosu, who is the Minister for Government Communications, I think he's Minister without portfolio, Government Communications, Minister of State, Government Communications, Felix Kwachiofosu. He released a statement that President Mahama has received petitions against the Chief Justice, and in line with Article 146 and the provisions thereof, these petitions have been shipped to the Council of State, and that the Council of State were looking at it. Now, some lawyers became concerned that a fundamental legal process is being breached, a fundamental legal maxim, a fundamental principle that underpins the law of rights is being breached. It is the principle that says that you must hear other side. All the term pattern, they say you have to hear the other side on every matter before you come to a conclusion. That is why the scales of justice tilt. They don't tilt anyway. They are equal, because you have to hear the other side. Is one of the principles that underpins the scale. Okay, so they went to court through. One of them was a member of parliament, Mr. Asifo, a member of parliament for Tafo, and he went to court asking lawyer Godfrey Dame to file the processes for him. Godfrey Dame being the former Attorney General, of course. So he filed these processes, and the court panel was constituted to hear the matter. Many legal observers were watching whether Justice Tokonu will empanel herself, because she had the right to do so. She has the technical power to do so. And this matter was about her. It was about her impeachment. So that if she empaneled herself, she has 1 vote her way. And there's no law against it, as it were. There's no technical law against it, as it were. So the panel came out as follows. Justice A.J. Frimpong, Justice Darko Asare, Supreme Court Justice Yao Jewu, Supreme Court Justice Henrietta Mensah-Bonsu, Professor of Law, and Supreme Court Justice Adibu Asiedu. These were the 5 lady and gentlemen who were empaneled by Justice Tokonu to hear the matter about whether or not the president, in transmitting the petition to the Council of State, has jumped 1 step. And the step he had jumped was indicating a kind of breach in bad faith, because it was important that Justice Tokonu got it. Now you will see in a letter that President Akufo-Addo wrote to the Council of State that a petition had come to him and he had forwarded it to the subject of the petition, which is what one always needs to do. So Justice Tokonu empaneled these judges to look at the application that had come before the court, which was directly impacting her continued role as Chief Justice. Sometime along the story, Justice Tokonu then wrote a letter to President Mahama indicating the same thing, that she is yet to receive the petition, but she understands that these petitions have been forwarded to the Council of State. In response to the letter, President Mahama berated Justice Tokonu for leaking her petition to him, to the media, because President Mahama said he had also seen it in the media. He, however, responded to Justice Tokonu by forwarding the petitions to her and giving her 10 days to respond to the petition. It would appear at this stage that perhaps the matter before the court was moot, because at that time, the real matter before the court was what they called a violation of the Constitution by a breach of the rule of Adom Otchere pattern, which is here the other side, as it is said in Latin. However, after Justice Tokonu responded to the petition, word came round that the Council of State was being asked to consider whether or not a prima facie case has been established in the matter. If the Council of State were to consider that the prima facie case has actually been established, the process in Article 146 sort of kicks in. In the process kicking in, His Excellency the President is told in Article 146 that he may or may not suspend the Chief Justice. May suspend the Chief Justice. It then comes to the discretion of His Excellency the President, that in carrying out this discretion, he will be able to suspend the Chief Justice if he so desires. But he will be able to keep the Chief Justice in office whilst the processes of Article 146 continue. What is the next stage? The next stage is that a committee be set up to look into the matter. The membership of the committee is also determined by the provisions of the Constitution. So, the Council of State proceeded to look at the matter. One day we were there when the Council of State said that they have looked at the matter and they have established a prima facie decision. Lawyers were unhappy with the matter. And then they said that the President, not being a judicial officer, when he sees the word may, where he wants to exercise his discretion in a matter that is quasi-judicial, as this matter is, quasi-judicial just means that it has a semblance of a judicial matter, but it is not properly judicial because the President is not a judge of the Supreme Court. He's performing a role as of a judge, but it's quasi-judicial. So quasi-judicial, for instance, is that you work at Metro TV, and then they say you have done something wrong, that you have violated the code of ethics of the company. So they set up a committee, usually chaired by Adom Otchere, and the secretary is somebody else, and everybody is there. Then that exercise of that disciplinary action against the Metro TV staff is what we call quasi-judicial, because you are going to take a rule of conduct and you are going to interpret whether those rules of conduct have been breached. In doing so, you are sort of performing a judicial function as a judge of sorts, but you are not a judge, and you are not a high court judge, you're not a court of appeal judge. So what you are doing, which the law allows you to do, is a quasi-judicial function. It was said that because the President is exercising a quasi-judicial function, he, the President, ought to publish regulations on how this function is exercised, because it's a discretion and it's a constitutional matter. People say that in the best interest of the practice, we need to know ahead of time with sufficient predictability that when you get into this space, the President will exercise his discretion to do A or B. It should not be in the dark, and it should not be open-ended, where we don't know where, how, on what basis, and with what intuition that the President will come to this conclusion. But if regulations are published, we will know that if your matter is this way, that way, this way, then the President will come to this conclusion in exercise of his discretion under Article 146 of the 1992 Constitution. So this was the state of affairs at the time. So the lawyers went back to court, now amending their application, filing a new process, and saying that the Council of State and the President's decision to find a prima facie without telling anybody how they did it, and the President proceeding to suspend the Lord Chief Justice were unconstitutional. And so this panel was going to hear the matter. All right. So everybody was ready, lawyers were ready, judges were ready, media was ready, the people of Ghana were ready, showed up in court to hear the matter. What happened? Mr. Justice Adom Otchere was unwell, or so it was reported. He was unwell on that day, Justice Adom Otchere here. He was unwell on that day, and the president of the court, Professor Henrietta Mensah-Bonsu, told the lawyers, Dominic Ayini for the Attorney General and Godfrey Dame for the applicant, told them, that Justice Adibu is not here. The Constitution requires that with an application to the Supreme Court, as has been the practice, a minimum of 5 people will sit. In fact, that's the barest minimum under the Constitution with which the Supreme Court can constitute itself, except where the Supreme Court, in those instances where one judge can sit as one judge to hear an appeal from one of the lower courts in specific circumstances, or where a Supreme Court judge is sitting as an additional High Court judge or somewhere. Wherever the Supreme Court sits, the minimum number that the Constitution has granted is 5. It can be 7, it can be 9, it can be 12, it can be 13, but the minimum is 5. Therefore, with a panel of 5, that Justice Adibu Asedu was unable to show up, the panel could not really sit. It will be illegal for the panel to sit. So the case was called off, that it will be adjourned until sometime in May 6th or so, which was today. Now, 2 days later, more drama happens. A letter emanates out of the presidency and the Council of State indicating the process of the Chief Justice's Article 146 petition, the committee. The committee that was set up by the president names Justice Adibu Asedu as one of the 2 Supreme Court judges which the Constitution mandates must sit on that committee. 2 of them, Justice Adibu Asedu and Justice Gabriel Poamai, were the 2 that His Excellency named to be on the panel, and then 3 other people who are not lawyers and they are not members of the Council of State. Those 3 have also been named. Tongue started wagging. Everybody was concerned that Asedu wasn't on the case, he wasn't well, and now he's on the panel. Anyway. So it turned out that Justice Asedu cannot make it anymore on this panel. And people were wondering that here is Justice Asedu, who has already been empaneled to hear this matter, and now he has been selected to be on this one. What is going to happen? Is he going to come and recuse himself from this? What's going to happen? Nobody knew. In the meantime, the Chief Justice is suspended, and the senior-most judge, Justice Paul Bafoboni, takes position as the acting Chief Justice. Word gets round that Justice Bafoboni on day 1 of work is making a lot of significant changes here and there. We hear all that. All those changes have been made. No, fair enough. Okay. Now, let's get into the meat. So, Justice Bafoboni now has the right to do a new panel. What happens? Wait, let me go to... Yes. He takes out of the existing panel. Adibu Asedu, of course, is out. We know that because he's going to be on the panel for the committee that's going to listen to the Chief Justice in the substantive matter of the petitions against her. So he's out. And then Justice Bafoboni also takes out Justice Adom Otchere, who was originally empaneled, takes him out. And then he takes out Justice Eje Frimpong, who was originally empaneled. So these are the 3 judges that get out of the situation. 3 judges get out. And then 3 judges get in. Justice Leonie Kulendi, Justice Bafoboni, the acting Chief Justice, and Justice Amadou Tanko, all are 3 who come into the matter. The biggest controversy about this was the arguments that were made by the former Attorney General in court today. Now, he was concerned that Justice Bafoboni, being an acting Chief Justice, he said, is a direct beneficiary of this process. Therefore, Justice Bafoboni should not add himself to the panel, even though he does have the administrative right to empanel. Now, the Supreme Court heard the matter, and all 5 judges of this morning, including the 3 here, agree that the Chief Justice can sit. So they overruled Godfrey Dame on that matter. I've heard Supreme Court judges giving several reasons why the court ruled this way. But then this evening, when I spoke to another Supreme Court judge, he's telling me one thing, that there's another argument that I need to bring to the attention of my viewers tonight, why Justice Bafoboni can't sit. He says that to say Justice Bafoboni is a beneficiary of the process is not altogether wholesome and correct, because Justice Bafoboni has not been appointed the Chief Justice. He has not been told that he will be appointed Chief Justice. There's been no announcement that he will be appointed Chief Justice. The reason why he's there is because he is in an acting capacity on the basis that he's the senior-most justice at the Supreme Court. So he's not been appointed Chief Justice. He's acting in an administrative capacity as a senior-most justice of the Supreme Court. And therefore, he's able to sit on the panel. Because tomorrow, if the Justice Tokonu thing goes through and for whatever reason Justice Tokonu doesn't come back, the president can decide to appoint Amadou Tanko as a new Chief Justice. And Justice Bafoboni will revert to his role as the senior most. The consistent and persistent Deputy Chief Justice is the senior most judge of the Supreme Court. So as a Deputy Chief Justice, he's only stepping in the role of the Chief Justice because there's an administrative issue that he has not been appointed the substantive Chief Justice. This is what the Supreme Court judge told me tonight, that must also form part of the information that I share with my viewers so that they can make their decision whether it was right or wrong. It was not technically wrong because he saw the court rule in that way. But the question is, was it morally right? Was it morally incorrect? It's up to you, viewers. Look at it and let's see what you think. But more interesting revelations. Now, it was these 3 judges who were added today that swayed the court away into a majority of 3. I'm not reading anything into that. 3 judges here who came in. Justice Yoni Kolendi, Justice Bafo-Boni, and Justice Amadou Tanko were the 3 who ruled in favor, who ruled against the application, and therefore the application fails. The 2, Professor Henrietta Mensah Bonsu and Mr. Justice Jehu, ruled in favor of the application, that the application should succeed. Justice Bafo-Boni sat on the panel as well. So this is the story from the Supreme Court today. At 7:30, they went to the court. They heard Justice Bafo-Boni was sitting. A lot of conversations about whether he should sit or not. An application was filed. The application failed. But I'm telling you what another Supreme Court judge told me about what happened. But the other story is that, coincidentally, it was the 3 judges who came in this morning who delivered the majority opinion, which we are yet to read sometime in May, I think another week or so. I'm guessing that the majority opinion will be written by Justice Yoni Kolendi, and the minority opinion will be written by Professor Henrietta Mensah Bonsu. But there was a showdown in court. The case is not over. There was a real showdown in court. And I take the showdown straight away on the touch screen. Justice Kolendi says, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? Justice Kolendi puts the question to Godfrey Dame, the former Attorney General. He says, Mr. Dame, let me ask you, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfrey Dame says, my lord, the failure to give the Chief Justice notice. So Justice Kolendi says, what will be the substantive constitutional breach in respect of this? And it says it is the failure to give the Chief Justice notice. That's what Godfrey Dame says. Simplifies the matter. Then Justice Kolendi continues. It is a question of time as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Justice Kolendi was piling pressure on Justice Godfrey Dame to demonstrate where is the constitutional breach. Show me the constitutional breach. Is it, what is the point? Article 146 says what? Does it say when, at what time? It doesn't say. That's Justice Kolendi's question. Let me read it again. It says, it is a question of time, comma, as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Godfrey Dame says, the Constitution is silent on that, and that is the essence of the constitutional issues before this court. I like the banter. The judge says, show me where the thing is. The lawyer says, it is not there. That is why you are here. The purpose of the Constitution, the Supreme Court, is to give clarity to things that are either not in the law that ought to have been there, or things that lend themselves to 2 or 3 interpretations. That is the essence of the court. If there was a black and white situation, Article 146, we will not be here, my lord. We will not be here. We are here, and you, the law, your lordships, are empowered with experience and learning and teaching that can help us to be able to go through this process in a way that a constitutional court works. That was the banter between Justice Lord Kolendi and Godfrey Dame. But as if Professor Mensah Bonsu was listening to both of them, she then entered into the fray with Justice Sremsai in this way. She said, "The right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Address the court on this, learned Attorney General. Address the court on this." So she makes a substantive statement and says, listen, the right to be heard is a constitutional right. And Article 23 requires that administrative justice should respect this right. Please address the court on this one. And then Justice Sremsai, the Deputy Attorney General, says, "My lords, the right to be heard has been provided in the procedure outlined in Article 146. Hence, the issue is at what time the enjoyment of this right is to be respected. At what time the enjoyment of this right is to be respected." And then Professor Mensah Bonsu says, "Should the enjoyment of this right accrue after the respondent, the Chief Justice, has been tried in the court of public opinion?" Sremsai says, "My lords, I rest my case." So they are talking about rights. Professor Mensah Bonsu says, it is a right for everybody to have the right to be heard. Show me how this right should be enjoyed. He says Article 146 provides that the right can be enjoyed. But it doesn't say at what time the right should be enjoyed. You see, the president gets the petition, sends it to Council of State. The argument is that president gets the petition, send it first to the subject before the Council of State can have the petition and what the subject says so that they can come to a conclusion of a prima facie. But you don't send to the Council of State only one side of the story and ask them to do a prima facie. This is the conversation going on. And they are saying that where, at which point. And Professor Mensah Bonsu is saying that, okay, if you're asking me at which point or that the Constitution is at which point, are you suggesting to me that it's okay for you to give the document to the person after you have tried the person in court of public opinion? That is to say, after everybody has seen the petition and is gone to Council of State, is it at that time that you are going to give the person the right to be heard? After the public has seen, after the Council of State has seen, after they may have prejudged the matter, after they may have made their opinion, is it at that time that you are going to show to the subject? This was a conversation between Professor Henrietta Mensah Bonsu, who was on the minority side, writing the minority opinion of 2, and Justice Sremsai, who is the Attorney General, Deputy Attorney General, and Deputy Minister for Justice. Justice Sremsai, in answer to the rhetorical question by Mensah Bonsu, said, "My lords, I rest my case." Okay, so this is how it ended. I'll come to Professor Mills and... not this one yet. Professor Mills and President Mahama. Let me deal with the live coverage in a separate issue. Then I'll show Professor Mills's video. Or let me show Professor Mills's video first. I'm sure that's why this is here. When Professor Mills was president and President Mahama was the vice president, there was a press conference, and I attended. In those days, there was a lot of hue and cry about the Chief Justice should be removed. The Chief Justice in question was Justice Theodora Wood, that she should be removed. The NDC had felt that she had been bad to them, and she's an NPP woman, and she's a sister-in-law of Otchere, who was a member of parliament for the NPP and a dying-in-the-wool NPP Otchere, and they thought that the woman, Justice Georgina Wood, was biased, and that Professor Mills should proceed to remove her. There were public conversations about this, and Kwabena J, may he rest in peace, the former chairman of the party, who said that if Professor Mills will not remove her, then there are many ways of killing a cat. Those of them, though, is worrying that applications were made for the coverage, the live coverage of this case. The first application made here was by the law platform, and we know that the Justice Tokonu was allowing the media to cover cases live, and all of us were very excited about it. So the law platform wrote that the law platform is an online law magazine available at www.this. The magazine is dedicated to the publication of legal news, legal articles, etc., etc. And they said that owing to the huge public interest in the matter, that the matter holds for the benefit of the members of the bar and public at large to have the opportunity of full and live proceedings in this landmark case. We are humbly hopeful of my lady's request. That's one judge that Tokonu was there. The application was repeated to Justice Bafuboni, and it didn't quite happen. Now, 2 days ago, yesterday in the morning, we came here and we discussed this. And so we put out this letter to the Lord Chief Justice, and we'll read a little bit of it. Vincent Ekwasefoa versus the Attorney General. And it says here, now I signed the letter here in the office to send to the Chief Justice for live coverage by Good Evening Ghana and Metro TV. And this is what we wrote to the Chief Justice, that I am Paul Adom Otchere. I should have added blogger Bakope. I should have added that I am Paul Adom Otchere, blogger Bakope. The host and producer of Good Evening Ghana, a Ghanaian primetime current affairs TV program, which airs on Metropolitan Television. And I write to your outfit to pray for leave to provide a live coverage of the proceedings of the 6th of May 2025 in the case of Vincent Ekwasefoa versus the Attorney General. The practice of giving the media the opportunity to cover high public interest cases in the superior courts of judicature has become conventional in the political and legal landscape of our republic. From the 2012 election petition, where the then Chief Justice, Honorable Lady Georgina Wood, through an administrative fiat, granted permission to the media to provide a live coverage of the proceedings in the said case. This was hailed as a step in the right direction, which sought to deepen our democratic culture and heighten public interest in the judiciary. Subsequent to this pivotal period in our history, the judiciary has placed its shoulders to the wheel in ensuring the publicity and coverage of such court proceedings in the cases such as 2020 election petition, John Mahama versus Electoral Commission, Alexander Markin versus Speaker of Parliament, Richard Delasky versus Parliament of Ghana, in line with the aim to foster transparency and interest in judicial processes by the common man. It is the humble prayer of my production team and myself to be granted the permission to cover the proceedings of court on 6th May 2025 in the case of Vincent Ekwasefoa versus the Attorney General. This will aid in promoting and deepening the culture of democracy while equipping the interest of the public in the court system and in our democracy. Yours faithfully, Paul Adom Otchere. Viewers, I signed this and we were not allowed to show it. I don't know whether it's as a result of lack of time. I'm not sure what it is, but I'm pleading to the acting Chief Justice that if the matter comes up on review, all of us, the media, are going to put out these kind of requests, and we're expecting that in following the best practices of your forebears, the Lord Chief Justice, Justice Paul Bafoboni, will allow the media to film inside the courtroom the applications for the review of this matter before the Supreme Court, because Ekwasefoa has asked for a review. The circumstance of the review is that 2 judges are going to be added to the 5 that have made the determination. 3 on one side, 2 on the other side. 2 judges are going to be added. If all 2 judges go with the 2, then that will be 4-3. If all 2 judges go with a 3, then that will be 5-2. If 1 judge goes with a 3 and 1 judge goes with a 2, that will be 4-3 in favor of the 4-3 against the application. That's what it will be. We are hoping that now that Justice Paul Bafoboni has had a bit of time, if the review application is filed and a date is given, we are going to send him letters asking him to allow us to film for the benefit of the Ghanaian public, and we hope that he will do that. We sincerely hope that Justice Bafoboni will do that. Producer, the NDC story, we will hold it on until after the 100 days. 100 days is just tomorrow. 120 days is just tomorrow. President Mahama will be speaking. And so when he's finished speaking, we can get more information and deal with this. We have a big story coming up here, but we'll do that later. It's 11 o'clock. Let's go to the text messages and see what people have been saying. Who shall I start with? Antoinette, what are people saying?
Right. Thank you so much. Now, Real Maxby is begging to differ with the statement that Paul made. He says, I beg to differ with the retired Supreme Court judge who spoke with you. What if Justice Bafoboni is rewarded by Mahama to become the substantive Chief Justice after all this brouhaha? Wouldn't Godfred Dami be justified then at that time? Now, Nixon Nation is also begging to differ. He says, Apostle Paul, I strongly disagree with the Supreme Court Justice who said it's not entirely that Justice Bafoboni is only acting to do administrative things. Is the justice saying being an acting position doesn't bring in any benefit or authority? Once an acting person gets to benefit from that scenario, it is prudent for him to rescue himself from the panel. Mr. Dame's objection should have been upheld. For him to recuse himself, from the panel. Now, Sofianu Adam says, good evening, Paul. So now the judiciary has equally been politicized to the level where every court ruling is seen in political lenses rather than the law. That is very dangerous for our democracy. Are we then saying that every case won at the court should be related or linked to the government of the day? We need to get serious as a country because such things have a bad influence on our system, especially our last hope, which is the judiciary. Nana Owusu says, in fact, I find it hard to believe that a country of 32 million people would sit aloof to be scanned by some five whiners with a so-called petition leading to a chief justice. Are we serious as a country? Now, Rex Quick, who is giving an account of what he thinks is happening at the Supreme Court of Ghana, he says, due to what happened in Ghana's Supreme Court today, I would urge everyone concerned about our judiciary to allow the government to go ahead with the decision of removing the Chief Justice. I am of the firm belief that the current acting Chief Justice, which is Bafuboni, and some of the justices of the Apex Court are against Madam Tokponu. They are only concerned about their personal positions and personal glory and not the future of Ghana. Bafuboni is morally corrupt as man. The rest of the Supreme Court justices who are supporting the heinous action of the NDC government will live to regret their actions whilst alive, and history will never forget them. Now, lastly, Samuel Ofosuba says this whole entertainment in our jurisdiction is way too much. From the presidency to the grassroots levels, please let us be serious for once. Just look at the president. Instead of giving an important speech, he talks of alcohol. Ghana, Mother Ghana, arise from the slumber, for your children are perishing. Patsy.
All right, thank you, Anne. So this is coming from Kwame Sapon, and he says, if Professor Mills declined to be a cat hunter, it seems whoever removes the Chief Justice is the cat hunter. Abdul Fattah says, when we say we should not politicize the judiciary, we should get it right that it is the 1992 Constitution that has politicized the judiciary by giving the partisan political president the power to appoint the CJ. Other justices and other judges of our courts in the first place, we should expend our energies at the CRC to get the wrongs in our Constitution, expand to save our country from the destructive path of both the NDC and the NPP. Samuel Fosuba says the late President Mills' short video showed speak volumes of parable to the current leader of government. If he hears the voice of his late boss, he will bow down his head in shame. Now, Gabriel Malik says there are different languages used in the 1992 Constitution describing the action of the President with the Council of State as follows: in consultation with, on the advice of, and in accordance with. If the interpretation of the words above are different and apply to the President in specific circumstances, then they should be explained and not construed as same. Master Planner Jr. from Kentampo says President Mahama and his NDC do not believe in the rule of law and they seem to be flaunting the laws of Ghana. This attack and the interference on our judiciary is sad and dangerous to our democracy. The demonstration shall continue in different regions if President Mahama does not reverse his decision. The Chief Justice Tokono must come back. Yao February says this is the beginning of the manipulation of the judiciary by the presidency for interested judges to sit on cases. And lastly, coming from Anofo Joseph, says, in fact, it's obviously clear that the AG is going to be embarrassed at the end of the matter between him and Mr. Edubuahin. But my worry is whether the accused will be compensated if found not guilty.